Good morning, everyone, or good afternoon, depending on where you are. My name is Loukas Mistelis. I'm one of the team that will be teaching arbitration modules. And I'm here with Professor Brekoulakis, who is going to introduce yourself very briefly. And then we'll come to the agenda. Stavros, would you like to take the baton?
Yes, good morning and good afternoon, everyone. My name is Stavros Brekoulakis. As Professor Mistelis said, I'm a professor of international arbitration, and I will be teaching modules in relation to commercial arbitration, construction arbitration, and litigation.
So what we plan to do today, we're going to give you a bit of an introduction to Queen Mary and the Center for Commercial Law Studies, where the School of Arbitration sits. And then we will talk about our modules, but also the mode of delivery and what are sort of the particular sort of focus of attention in the way we offer our modules. In a normal environment, we would have liked each of you to introduce yourselves, but perhaps what will be very useful is if you were to use the chat option of Zoom and just write your names and the country where you come from. So Queen Mary University of London is one of the younger universities in London. But of course, young doesn't mean really very young. It's more than 125 years now in operation. And the Center for Commercial Law Studies is one of the departments of Queen Mary. So Queen Mary has a very interesting history, developed based in East London as an engineering college, and then eventually has grown to a very significant university. Is a research active university. Which has a particular focus on globalization and diversity and internationality. So both the student population, but also the faculty are significantly diverse, but we also are recognized as a research leading university, and hence we are part of the Russell Group. Now, the Center for Commercial Law Studies was created about 40 years ago. It was the vision of Professor Roy Good, who is still active in some form in various activities of the school. And the idea was that he wanted to create a unique postgraduate law department that will offer research capability and teaching in areas where historically universities did not pay much attention. So this will cover, for example, areas like tax, dispute resolution, banking and finance. Of course, now CCLS has grown and there are many more areas. There's telecoms, media, and technology. There is a very vibrant IP community. There's economic development, there's shipping, insurance, finance, and so on. So we think that we occupy a space where we have the capacity to offer training at a high academic level for people who want to go either to practice or to academia, and the clear motto of all our faculties is our research-led teaching. So effectively, everyone teaches in her or his own specialization. We don't have obligation to teach modules we don't want to teach, and that sort of research-led teaching will be clearly visible to you by the enthusiasm that every of our colleagues will display. Now, the School of International Arbitration is the first place ever to teach and research arbitration in the world since 1985. Queen Mary has offered arbitration modules since 1983, but the school was created in 1985 and is widely recognized as the oldest and most prominent arbitral research institution in the world. So our particular attention is, as I indicated, specialization. We are a highly specialized school. We don't have very generic modules. Professionalization. We like to integrate practical aspects to our academic teaching. We are an academic institution. The tuition you're going to get is academic and not vocational. We do not prepare you for a profession, but we interact with the legal professions quite a bit. We look at the development of the subjects, and we see how that modernization and liberalization of legal professions, and arbitration is a prime example. Arbitration is a classical global profession that works over different borders, and with quite a high level of flexibility, how this liberalization of trade impacts on globalization, and of course also multiculturalism. So we do think that our LLM has unique features. We have a significant global network of alumni. We have taught roughly about 3,000 students over the last 35 years. And our students are in major positions all over the world. They're senior academics, they're heads of arbitrations, they work for government, but they also work in the private sector. So in this next section, Professor Brekoulakis and I will be discussing about our modules. And I will start very briefly by saying how the LLM will operate in 2020, 2021. We also, perhaps I should have said already that the School of Arbitration has been offering online teaching since 2003. So we were pre-Zoom, pre-Teams, pre-everything. We had developed a platform and a model of operation with students that was enabling us to have that distance learning for people who are not prepared to come to London. This has come very handy at the aftermath of the pandemic, and we now are prepared to offer, as necessary, blended learning, which means tuition face-to-face, but also tuition using technology. The other adaptation we do to our program is that in the next academic year, we're going to have 2 entry points. Some students will start in September 2020, and some students may start, if they wish, in 2021. We are ready to start in 2020. The modules are prepared. We are prepared to teach face-to-face. The building is being prepared for the necessary social distancing, but we also have the backup position of the online tuition, to which we have been trained over the years through our own experience, but also most recently. So we are not sort of focusing on the main London LLM on distance learning, but on a blended learning. We think that there will be enough scope for interaction face-to-face. And of course, that blended learning, apart from the educational experience, it gives us the capacity to have networking events in whatever way is necessary. The third innovation for next year is that we make the research dissertation an optional element, simply because students might want to have a few more modules taken rather than take a dissertation. But we do encourage students that have an interest in research, and particularly in doing a PhD, to do a dissertation. And of course, we are going to have a broad range of assessments, which we'll discuss briefly. We are not going to compromise on internships, careers, and all the like. So let's then go to our modules first, and I will come back to that slide a bit later. And I would like Professor Brekoulakis, or perhaps Professor Brekoulakis will speak briefly to that slide. Of course. And I will come back.
I'll be happy to speak. The slide that Professor Mistelis has there set out has the spectrum, gives us a spectrum of dispute resolution modules, and also reflects what happens in practice. So you see they're separated in terms of how mandatory or consensually based they are. We have flexible, inflexible, formal, more formal, consensual based, or adversarial proceedings, dispute resolution, covering a whole range. So if you look into the left hand of the spectrum, you start from negotiations, which is the more informal, the more flexible, and a consensual means of resolving disputes. The first thing that, if the parties have a dispute arising out of a major commercial transaction, the first thing they will do is engage in negotiations. These negotiations can be either structured under specific rules and specific procedures, or they can have informal negotiations with a view to resolving the disputes as less costly and as more time efficiently as possible. This is something, negotiation and mediation, the next one as you move into your right-hand side of the spectrum is what we call, especially this side of the Atlantic, ADR, Alternative Dispute Resolution means and modules or processes. Mediation is negotiation with the assistance of a trained person that will guide and direct the negotiations, what we call the mediator, with a view of bringing the two parties together, with a view of facilitating the discussions and eventually a successful outcome of these negotiations. Mediation has become very popular in the last 20-30 years. Is a very flexible and very informal means of dispute resolution, certainly if you compare it to arbitration, but at the same time has specific structure and specific procedures enabling the parties to come together. Mediation now is offered by trained mediators, as I mentioned, and is also offered under specific rules, specific mediation rules of all the major arbitration institutions, including the International Chamber of Commerce, the LCIA, and the AAA, the American Arbitration Association. Is becoming very popular, although there's a long way to go for mediation. Now, if you move right on the spectrum and you go now to arbitration, either commercial arbitration or investment arbitration, and we will come back to these two forms of arbitration in a while, you now have more structure, you more have less flexibility, but at the same time you have more flexibility if you compare again to litigation, which is the right hand corner that Professor Mistelis have shaded in red. So arbitration has become in the last 45 years arguably the most prevalent means of resolving international commercial disputes and certainly investment disputes throughout the world. It is popular with the parties because, at least initially, it offered a more time-efficient and less costly dispute resolution. It offers a lot of room for the parties to design the process, the arbitration process, in the way they want. But at the same time, and that's the main difference you will see with mediation, arbitration offers an enforceable final decision. The parties, instead of having a negotiation which successfully comes to a settlement, which is enforced like any other contract, in arbitration, the parties, the successful party at least, we will have an enforceable title, which is enforceable, as we will see during the year, through one of the most successful international conventions in the world, the New York Convention, which basically enforces an arbitral award even more efficiently than any court decision. So arbitration, compared to mediation, has more structure, has less flexibility, but it offers this binding outcome and this enforceability that some parties would like, especially if mediations and negotiations previously have failed to come to a successful outcome. Now, arbitration and mediation negotiation form a big part of our dispute resolution LLM. We offer a number of different versions, different types of arbitration, ADR, negotiation strategies, which we'll come to a minute to discuss. Lastly, we talk about litigation, as I said, is the most formal, the less flexible means of dispute resolution. It's the other coin of arbitration because it also offers a binding final outcome to the parties that won something that is they can enforce at the very end, but it's typically more costly and typically more time consuming, especially if you end up in some jurisdictions where court proceedings are not well known of being timely and efficient. We will discuss about litigation a little bit in the context of conflicts of laws class, the module that we will have to discuss in a while. But this is, in a nutshell, if you like, the whole spectrum of dispute resolution means, the dispute resolution options that parties have at their disposal once a dispute arises out of the commercial transactions.
And while you're going to see that a lot of our focus on the modules are in the mediation and arbitration, we do accept that there will be a lot of sort of interest in litigation and negotiation. And of course, that is being covered in many ways through the modules, because it's important for us to give you a global view. So, for example, if you take some litigation modules, you'll see that there's some interaction with arbitration. And even in the arbitration module, there will be some matters of court related arbitration related court proceedings. So let's now then move to the courses and see what we have to offer. Start with the ADR, and I have already noted that there's a question on chat about WTO. We'll come to that later. We have in the ADR sphere, we have 3 core ADR subjects and a 4th subject which is blended. The 2 main courses we have is the Alternative Dispute Resolution 1, which is the theory and context of alternative dispute resolution, looks at to what a dispute is, how mediation works, how negotiation works, what is the sort of element of psychology, the element of law, and all of these sort of more fundamental issues and contextual issues in order to place an ADR system. It also speaks about designing ADR systems and so on. This is offered by Dr. Debbie De Girolamo. It will be in semester 2 and is a 30-credit module. In semester 3, there's the second part of this module, the selected issues. Effectively, this is the interaction of law and ADR, or the interaction of lawyers with ADR. It's a very interesting practical aspect for lawyers, but also has a number of ethical issues to discuss. This module will be offered by Dr. Daniel Ben, and it will be in semester 3 and is a 15-credit module. Now, the third core, if you wish, ADR module is the negotiation theory and practice. This is in semester 2 and is a 30-credit module offered by Dr. David De Girolamo. And this looks at negotiation from a 360 degrees, if you wish, perspective. So it will look at all the aspects of theory that an evolution of negotiation, but they will also have a number of practical exercises where you will be engaged in negotiations, whether by a two-party, multi-party, in a family law context or a commercial law context, and it will be quite a sort of hands-on, experiential learning. Now, the fourth module on that slide, the arts disputes and their resolution, is one of the modules which offered in very few places in the world, and we are delighted that Queen Mary is one of those. This looks at arts disputes and how arts disputes are being resolved. And in that sense, it will focus on mediation, negotiation, but also arbitration and litigation. It will look at various types of arts disputes, whether it's looted arts, a dispute about authenticity of art, and we have the Institute of Art Law, which is a University of London Institute and School of International Arbitration, to deliver this a rather pioneering module. And we also work with the Court of Arbitration for Art Disputes, which is based in the Netherlands, but it's a global center. So a very specific area of disputes, but sort of looked from a very broad perspective of how the disputes can evolve and how matters work. It's again a 30-credit module. Then we'll turn to our arbitration suite, and Professor Brekoulakis will take the lead to discuss actually most of the modules on that slide, and I will, when he's done, I will come to discuss the second bullet point.
Absolutely. As Professor Mistelis said, this is the range of the commercial arbitration / construction suites that we have here to offer. The two main flagship, I would say, modules is 043 and 044. These have traditionally been the two commercial arbitration modules that Queen Mary and the School of International Arbitration has been teaching since the 80s. As Professor Mistelis said, teaching started in 83, but the School of International Arbitration then was founded in 84. It was the first commercial arbitration module that was taught anywhere in the world, and we are proud that we continue after 30 plus years the teaching of international commercial arbitration. Now, we have broken down the commercial arbitration modules into two different modules. One taught in the first semester, this is the 043, and the second taught in the second semester, 044. They are both 30 credits. They are both cover a wide range of both theoretical and practical issues. The way it is broken down is as follows. In the first semester, we will cover topics including the theory, the framework, the legal framework, and the historical discussion of arbitration, how commercial arbitration came to be practiced globally. We will then look into arbitration agreements, the jurisdiction of the tribunal, the authority and power, the scope of arbitrability. What are the issues that a tribunal can teach, a judge can address and cannot address. And then we will finally end with discussion about the challenge of the arbitral awards, how an arbitral award is to be issued, and then how it is to be enforced. So 043 will prepare you for all the theory that you will need to know to move on to 044 in the second semester, led by Professor Mistelis. And this will now focus more on practical and procedural issues. This will include evidence, how evidence is taken, what is the procedure that is to be followed by tribunals, what are the rules that form the procedure, arbitration laws, institutional rules that tribunals follow, some practical guidance, some soft rules, including the IBA guidelines on the taking of evidence, the conflict of law interest. All of these issues that guide the tribunal's decisions will be discussed from a practical perspective as well. Issues about tribunals' independence, impartiality, joinder of third parties, all the nitty-gritties that you want from a procedure in international arbitration will be covered from 044. So the two of them are usually taken together, not necessarily, but this is what we usually advise to the students, and students have found it very helpful to take them together. And they're also going to be supported by a range of tutorials. As Professor Mistelis said earlier, we're going to take a blended approach, so some form of in-person tutorials will be supported students in smaller groups throughout the 2 semesters, which we think is an integral part both of the learning process, but also of the formative assessment of our students, the formative feedback that we give to the students through the tutorials. The students there have the opportunity to engage in more in-depth discussions, exchange views in smaller environment, but also address some of the tutorial problems, both theoretical and practical problems that the tutors will ask them to address. Now, 043 is assessed at the very end with a final examination of 2.5 hours, and the same is taken by 044. At least it was last year because of the COVID. We'll have to see again what are the circumstances of the COVID, and if there is the opportunity for the students to take an essay instead of examination question, Professor Mistelis will let them know. Otherwise, there will be also an examination as it was for this year. Unless Professor Mistelis has something else to add, I can move to construction arbitration.
Perhaps what I should say, I think my own experience is that students who take both modules get a more global view of arbitration, even if they have done some arbitration before, for the very simple reason that these modules are quite more advanced, both in terms of academic coverage, sort of the thinking, the underpinnings, sort of the global debates, but also on the more practical. So while 43 will be giving you the context and the academic debate, the 44 will do both this, but also will take you into the arbitration room and see some debates that are to be had about how issues of procedure and applicable law are being dealt, and also will raise your awareness about the need for some good background that you can develop at some stage about on private international law, comparative law. You need to have that flexibility and accessibility to be a good arbitration lawyer.
I think the point that Professor Mistelis made about seeing the arbitration room is very important, because this is our approach. We just don't teach only the theory, although a big deal of our modules are focused on the theory, but we also try to connect students with the practice of arbitration. We are professors, but we both practice arbitration from different capacities in different forms. So we have a good hands-on experience also from the practice of arbitration, and we want to transfer that to the class room. Also, because we, again, given the circumstances, we will have some practitioners coming into the classes and take some of the classes to the students. And we organize, especially at the end of each of the module, an informal roundtable discussion where we invite practitioners or people that work for arbitration institutions so that they give their own perspective. So indeed, the point that we want to strive and give the view from the arbitration room is an important one. And also this applies to 044, the International Construction Contracts and Arbitration, which is by definition and by nature a very practically oriented module. Construction arbitration disputes are, by reference to the statistics of the ICC, the most popular arbitration disputes worldwide. And that's very easy to understand. There's hundreds of thousands of construction projects around the world. They're bound to give rise to disputes. There are projects that last for many years, and therefore throughout the years, some disputes will arise. And so we've been teaching international construction contracts and arbitration since 1987. Again, the first institution that taught construction arbitration in an academic institution, and we're still proud to be giving this module. The module, the syllabus is split to two different parts. The first part focuses on the substantive provisions of some of the most popular construction contracts, typical construction contracts, which here includes the FIDIC contracts, which is, for those that are not familiar, these are the contracts that are promulgated from the Federation of International Engineers, and these are the most popular standard forms of contracts that are used especially for international construction projects and developments. So we're going to look into how risk is allocated between contractors and engineers. What are the duties, the responsibilities that each of the parties have there? What are the remedies? What are the contractual entitlements that the parties have and how they can be enforced? So this, for you to understand how disputes can be resolved, you need to have a very solid background of the substantial provisions of a typical construction contract, and this will be the first part of the semester. Now, the second part of the semester will then turn its focus to adjudication, arbitration, and mediation in the context of construction disputes. So to speak, the dispute resolution aspect of the construction arbitration. And here we're going to focus on the ICC rules in particular, not least because the ICC arbitration rules are the default provisions that you can find in a FIDIC contract that I talked about 2 minutes ago. The approach of the teaching is, again, international. We're not going to focus on any specific jurisdiction, as we're not going to focus, I should have said, in the first two modules. We take an international and comparative approach. So we look into different jurisdictions, a wide range of different arbitration laws and international instruments. So you don't need to have any particular background on that. It's comparative, international, and practical as well. The assessment is also going to be offered in the form of a final examination where students will have to address both practical and theoretical type of questions. It is a 30 credit contract. It used to be taught on a Thursdays in a 3-hour module. We will have to find out the particulars about the dates again later on. But this is as far as contracts and arbitration is concerned. Now, the final module here in the list is something that has become quite popular in the last 5-6 years. It is called Ethics in International Arbitration and focuses on a small slice of the arbitration discourse currently, a small slice but important slice nevertheless of the discourse. It focuses on some of the challenges, the ethical challenges that the practice and theory of arbitration has given rise to, including conflicts of interest, the role of the funders, the role of the tribunals, ethical questions in relation to the approach of counsel and advocacy. This is taught by Professor Catherine Rogers. It is in the 3rd semester, and it is a shorter module. It is only 15 credits, and Professor Rogers tends to take this in an intensive format, 5-6 days daily, or she usually breaks this into 2 different 3 and 2 days module. Again, the particulars of this are going to be discussed later on, but this is what this module will be focusing. We'll be focusing on a small slice, but a very important discussion on ethical topics and concerns in international commercial arbitration.
So we continue with more arbitration modules. We have, as you see on these slides, 2 modules: the investment treaty arbitration, foundations, jurisdiction, and procedure, and the investment arbitration agreement and substantive protection, which is in semester 2. Both of these modules are 30 credits. The first module looks at what it says exactly, so the investment arbitration, or if you wish, the broader ISDS debate, so investor-state dispute settlement. We will play quite a bit of focus on ICSID and how ICSID proceedings are organized, both in terms of arbitration, but also mediation, conciliation rather, in the technical language. We look at issues of jurisdiction, and also we look at the various other fundamental aspects of jurisdiction, for example, issues of most favored nation clauses, denial of benefits, and all the associated issues. In the second semester module, the investment arbitration agreements and protection, the focus will be on the text of multilateral and bilateral investment agreements and free trade agreements with an investment chapter. So we'll see what this protection looks like substantively, what is expropriation, what is fair and equitable treatment, what is protection and security. We'll also be looking at umbrella clauses and similar terms. And we'll also be looking at the evolution of these agreements from the old type VATs to the more modern VATs to the FTAs and the new models that we see particularly in Asia, the CPTPP, which sort of brings together a number of Pacific Rim states and South Asian states, the Regional Comprehensive Economic Partnership, the new NAFTA, and also how the new treaties are going to be looking. So we look very much at this evolutionary process, and we focus very much on what type of protection an investor might have, what type of defenses state might bring in the event of a dispute involving investment agreements. The first semester is assessed with a take-home paper, which has a particular practical aspect. You are expected more or less to think of having a senior partner in a law firm who wants to know something on a particular recent decision of an arbitral tribunal. So you have to write a case note summarizing a recently published award, and also take that and give a bit of more academic aspect to that paper. So not just the case note, but the case note plus a bit of more theory. The second module looks very much on, is assessed with a traditional 2.5-hour exam paper that will give you an opportunity to sort of revise a broader aspect. And there will be tutorials from both modules. There will be a lot of interaction of learning how to read cases properly, how to read cases quickly. Some of these become quite busy and quite long, and how to sort of extrapolate the key issues of any bigger judgment and bigger award, and also how to apply them in a number of actual scenarios. I would just like to briefly mention, I'm not going to spend too much time, two specialist dispute resolution subjects. We also have an energy arbitration module where we look at different types of energy disputes and how arbitration is being used in that context. This is a module offered by Professor Maxi Scherer in the second semester. It's a 30 credits module. And there is also another module offered by Dr. Miriam Goldby, which looks at shipping and maritime arbitration disputes. Perhaps it has quite a bit of focus on the English Arbitration Act, where London is still one of the most popular venues for the resolution of shipping disputes. These are specialist modules, are taken very well with other modules in energy or shipping LLM, and they are perhaps, if you wish, the classical arbitration module that students from the shipping or the energy specialization would be taking. Of course, investment is taken very much as well by energy students, because there's quite a bit of natural interaction there. So the final module is a litigation module, or a litigation and conflict of laws module, and focuses on commercial conflict of laws.
And this is, again, a typical dispute resolution module, in the sense that in order to have a dispute resolved, you need to know what is the law that will apply to it. So when you have parties coming from different jurisdictions, you don't know whether the law of one of them will apply or the law of a different country will apply. So very often the parties will include in their contracts a choice of law clause, and they will resolve the issue of the applicable law. Some other times they will not. And so the question comes up, how is a national court determine which law will apply when it wants to resolve a dispute? And here, typical questions that will be dealt with in this seminar is characterization, issues of the law applicable to contracts, but also the law applicable to torts, how you determine the law applicable in property disputes or company-related disputes. There are going to be also discussion about the role of mandatory rules, public policy, and how this public policy and mandatory rules will have to intervene even if parties have agreed to a law in the first place. They're going also to discuss very interesting and popular discussions. What will happen in the UK after the Brexit? You know, what kind of conflict of laws will English courts will apply? And I'm saying English courts because English courts have traditionally been the most popular international courts for international disputes. Other than that, the module will focus on also European regulations, including the Rome I and Rome II regulations applicable to conflict of laws for contractual obligations and non-contractual obligations. It is a 15-credit module and will be taken by two of our visiting professors, Dr. Roman Hodikin and Mr. Andy James, a former Beagle research fellow and now practitioner, and Dr. Roman Hodikin is also a practitioner partner in a big law firm. It is 15 credits and it will be taken in semester 1. It will be examined at the end with the final written examination.
So one final comment, and then we will, and then we can take questions, which come also through the chat. One of our approaches, as you have understood, is an integrated and interactive learning. So not because of COVID, but it has been the practice of the school that teaching and learning is an interactive approach. So we will be conveying content through the lectures, but there will be also seminars and tutorials where there will be quite a bit of interaction. And the tutorials are a very good opportunity for formative feedback. You will be, as you study, you will get a bit of a clarity as to whether you approach the topics in the right way, how you can improve your approach to the topics, and this will be consistent throughout all the modules. Now, in addition to the normal lectures and classes, we have a number of seminars. We have what we call the co-curricular seminars, where we have an opportunity to go deeper into some topics which are not fully covered through the classes, and where you will have an opportunity to interact with practitioners, bring their own perspectives. We also have a number of networking events, with a very big networking event at the end of the academic year, where we invite the biggest law firms in arbitration in London, and each of them brings one partner or one associate. And so effectively we have an opportunity to meet them over a glass of a drink or two, and then you can see what they like to see in candidates and what they particularly expect from a future associate to have. We also have, through the networking events, a number of internships. Queen Mary has a very strong careers office, and we have also a number of traditional good links with law firms and even in-house legal teams, for example, with the GE Renewable, where at least half a dozen of them will be taking regularly Queen Mary students from our program for a longer period of time. For example, GE will take them for a full year. There is a paid internship. Some of the shorter internships are not paid, but still a very good opportunity. And depending on how the world is going to be looking next year, I hope we'll be looking better than 2019. We are also going to be offering support for moot competitions, and Queen Mary has participated effectively in all the major moots.